Welcome back. Will Worsham joins us now for this week's Speaking Legal discussion, where he answers a viewer's legal question on air. Good to see you again.
You too.
All right, let's take a look at the question. My father is getting older and is getting to the point where he can't remember details, especially financially. We're also worried about his ability to take care of himself on his own. What can he do? I was looking to see if my kid's signatures were on. No, what can we do?
Sure. Well, you know, there's a couple of things here, and it begs the question, so just let me tag it right up front. This is the type of thing we like to plan for ahead of time. Yeah. We can put some guardianships and some trusts and some things, well, not guardianships, but powers of attorney type things in place ahead of time to take care of this scenario so it doesn't kind of fall in your lap and the kids wonder what to do is at the right time.
And you probably don't want it to go to guardianship, right?
No, and that's actually what we're going to be talking about is guardianship. And that's what has to happen. Once you're to the point where you are already can't remember the details and are starting to become incapacitated, you no longer have what's called competency. You no longer have the competency to give someone power of attorney. It's too late to give a power of attorney. In fact, unless it's a durable power of attorney, that power of attorney is only good while you're competent. It's kind of an interesting thing people don't really understand. So you want to do a durable power of attorney, that way it lasts past your incapacity and continues to allow people to do things on your behalf once you're incapacitated.
Who decides you're incapacitated?
Well, actually, a court ultimately would make that decision with the advice of your doctor and maybe even some live testimony. So let's talk about this situation right here. What they're going to need to do is apply in probate court for guardian and conservatorship. Guardian is of the body. That's where you take care of somebody's physical needs. Conservatorship means you're in charge of their estate. That means their finances. And in a situation like this, you're going to need both. And you can't just come in and take over. We have some protections against that. So what happens is you file a petition in the probate court asking to be appointed guardian and conservator over this person. At that point, the probate court will appoint a lawyer for the proposed ward, the father in this scenario, who will then go out and actually interview and meet with the client, the proposed ward. And in some cases, you go out and have that meeting, and I've been appointed in that scenario before, and you go, yeah, okay, this person needs a guardian, needs a conservator, and you have the conversation with them, and they have a right to be at the hearing if they want to be. They're not required to be. In some cases, you'll come back to the court as the appointed attorney and say, I have met with this person, and I don't have any objection. They did not request to be here, and it appears to me that they do, in fact, need a guardian and a conservator. I've been in other scenarios where the proposed ward objected and came to court, and we put them on the witness stand, and they told why they thought they didn't need a guardian and why they thought they didn't need a conservator. And then sometimes you'll have the doctor come in and testify to their opinion, either pro or con.
And rightly so, it's not necessarily an easy procedure.
Sometimes it's easy. Sometimes it's obvious. Sometimes you'll have somebody who's maybe even in a coma from a car wreck.
Well,
and so that's easy. And you get a doctor's letter, and sometimes it's very kind of perfunctory. But sometimes it is a hearing. And in a situation where dad here maybe is starting to lose the ability, you know, he may come in and say, hey, I don't need a guardian, and I certainly don't want you people, and then you've got to get a judge involved, and a judge has to decide.
Now, where do you go if you have, like if we were brother and sister, and no, I don't want you to be guard, no, I don't want you to be guard. Where does it go at that point? Family arguments.
It's still in court. It all gets decided in court. And then everybody gets lawyers, and there's 3 or 4 lawyers on different sides of the lawsuit, and maybe brother and sister agree, dad needs a guardian and needs a conservator, but they don't agree on who it should be. And dad's saying, I don't need one at all. And so you've got a big, nice court fight, and wouldn't it be great if we solved all that ahead of time with a little bit of estate planning?
Have the conversation and go to that parent early on and say, what do you want to do? Let's work this out now.
You know, here's the thing. As I get older, I want to do it myself. I want to do it sooner than later and not put that stuff off.
Exactly. All right. If you have a legal question for Will, email him at wworsham@color10.com. He'll answer your question on the show. As always, Will, thank you so much.
You're more than welcome.
All right.
All right, coming up.